My lords, I had got as far as point 2 of the 4 points taken against us on Article 2.1e, which was the judge's point that the claim was a single claim in respect of damage to the ship, and we very fully discussed that as I introduced the subject, and I'm not proposing to repeat what was shortly and accurately summarised by Lord Justice Males as the submission I made. I only add on that point this observation that if it were right, either as an expression of the way in which Charter Party claims following casualties are articulated in London arbitration, or as a matter of the way in which the Convention requires you to view a claim when it comes to court for limitation, that the claim be treated as a single global claim, that would be a radical departure from the way in which similar claims have been viewed and analysed in the past. And I simply point you again to the Aegean Sea, where when you look at the report, it's in the authorities bundle at tab 13, you see that the judge has followed the approach that we invite you to take, which is to analyse the claim made by head of loss. And the where you see that is in tab 13 of the authorities bundle. The list of individual claims is at 227 in the bundle, right-hand column. You see there the list: owners' claims against Royal as charterers, value of the Aegean Sea, bunkers on board the Aegean Sea, freight, and indemnity against liabilities under Spanish legislation. And then at 251, sorry, at I'm chopping and changing between, at 51, 51 of the report, which is 235.
Sorry, I'm afraid I'm getting very lost with these numbers. You said 277.
So I started by showing you 227.
227 of what? Sorry,
of the authorities bundle.
Yep. Okay.
At tab 13.
227. Sorry, I misheard you.
Apologies.
My fault. 227. Yeah, thank you.
227 right-hand column. That's the list of claims.
Indeed.
And then in fact, strictly starting at 234 at the bottom, under the heading Issue 2, are the claims put forward by the owners against Royal as charterers within the scope of Article 2 of the 1976 Convention. And then you see that what follows is a head-by-head analysis. There's the claim for the value of the Aegean Sea at 235, the claim for bunkers, 235 across the page, the claim for freight, and then the various recourse claims. So we simply say the judge's approach is not reflected in the Aegean Sea, and likewise it's not reflected in the CMA Jakarta, where again the individual heads of loss, perhaps you turn to tab 15 and look at paragraph 5, you see that the claims, and the claim is simpler in the CMA Jakarta. There are 4 items of loss. Paragraph 5 page 269. But then you see that the individual heads of loss are analysed separately. There's what he holds to be loss or damage to the ship at paragraph 22 and following. And then at paragraph 29, ship owner's liability to salvors. At 30, liability to contribute to general average. At 31, indemnity from cargo claims brought by cargo owners. So again, we say a disaggregated analysis of the nature of the claim. So that's all I propose to say on point 2, the judge's global claim characterization. Point 3 is Conti's argument that the claim for discharge expenses is not limitable under 2.1e because for the purposes of that article, the claim is to be categorized or characterized as a claim for damage to the ship. And in that context, they rely on what I've described as telos and genesis, but they rely on the fact that the need to discharge resulted from damage to the ship, and that their purpose in discharging was to allow the ship to be repaired. And you get that argument pithily put in paragraph 60 of their skeleton. Now, it's in answer to that point that we make the point that I articulated in response to Lord Justice Mayles this morning, that applying 2.1e does not require you to ask whether the claim is to be characterized or could be characterized as a claim for damage to the ship. Not relevant to the inquiry under that limb of Article 2. And to understand that submission, or to put that submission in context, it is perhaps helpful to start with what the decision in the CMA Jakarta was. There is nothing in well, there is no reference in Article 2.1 to damage to the ship. You don't find those words in the article. The concept of damage to the ship, or the relevance of damage to the ship, was identified in the CMA Jakarta in response to the charterer's submission that they could rely on Article 2.1a to limit claims for the repair of the ship, for owner's liability to salvors, and for owner's liability to contribute in general average. Their submission was that these were all expenses or losses which were in respect of, that is, had a connection with or were regarding damage to property in connection with the operation of the ship. And the Court of Appeal rejected that, starting at paragraph 22, and saying that 2.1a is not apt to apply to losses in respect of damage to the ship. And the effect of that decision is what I described this morning as a dichotomy between non-ship damage and ship damage. And so in applying 2.1a, you have to decide whether a loss is fairly characterized or categorized as a consequence of damage to the ship or damage to the cargo. That dichotomy, our core submission is, that dichotomy has no relevance to the application of subparagraphs B to E of Article 2.1. They are not concerned with material damage at all. They are, as I said this morning, concerned with various types of economic loss. And you can just test that looking at the irrelevance of material of damage to the ship can be tested if you look at the terms of Articles 2.1b to E. The first, as we saw it, that's page 100 of the Authorities Bundle, tab 7. The first, as we saw, is delay. And it seems a reasonable assumption that most cases of delay following a casualty will be because of some form of damage to the ship. To say it is a claim for delay, if it were relevant to ask, is a claim for delay a claim regarding damage to the ship or in connection with damage to the ship, in respect of damage to the ship? The answer would almost always be yes. But the reason the claim is nevertheless limitable is because it's no part of B to ask that question. Likewise, I mean, let's stray into the difficulties of C unless you absolutely force me to, but likewise D, I said to you this morning, D presupposes that the ship has been damaged. Of course every claim under D will be in respect of damage to the ship. You are raising or rendering harmless a ship which has been destroyed. How could that not be in relation to a damaged ship? The reason it doesn't, as the dichotomy in A would, if it were applicable here, exclude the claim from limitation, it's because it's no part of D to ask whether damage to the ship, the claim is in respect of damage to the ship. You ask yourself simply whether this is a claim in respect of raising a ship in the stipulated conditions. And likewise E. It's very difficult to imagine, in most cases, presumably the reason cargo is being removed is because the ship's been damaged in some way. So we draw from all of that essentially two propositions. Number one, the proposition for which the CMA Jakarta stands as authority is that subparagraph 2.1a does not provide for the limitation of claims in respect of damage to the ship or the consequences of such damage. But conversely, B, it doesn't follow from that there is some implicit rule that claims which would otherwise come within the ordinary meaning of one of the other subparagraphs of Article 2.1 are not limitable merely because the claim in question could be said to be, in some sense, in respect of or concerning damage to the ship.
Lord Justice Longmore does say in paragraph 34, just after the bit he says how it's easy to characterise claims, that it is doubtless inaccurate to say that of all the claims that could be brought by an owner against a charterer, it will only be liability to indemnify the shipper owner in respect of cargo claims that he will be able to limit. But I cannot at the moment easily think of any other category where limitation is likely to apply, which seems to be perfectly general and not specifically limited to Article 2.1a. Do you just say that's a failure of imagination on his part, or what do you say about it?
It is all of the cases that we are dealing with are exceptional cases. So to say that it won't routinely be the case that an owner's claim against a charterer is limited is merely to recognise that what we are dealing with in this case is an exceptional situation. But it would be to take the authority even of a far-sighted judge like Lord Justice Longmore too far to say that he was contemplating facts which were not before him. Okay, the submission made by Conti at paragraph 60, and this is in the core bundle at 311. Is that Conti only incurred these costs, i.e. the cost of discharging and cleaning the tank, the containers, because the sound and damaged cargo had to be removed and rendered harmless before the damage to the ship could be repaired. These costs were therefore, in essence, part of the repair cost and a consequential loss suffered as a result of the damage to the ship. Now, I've made my submission, I won't repeat, that for the purpose of the application of 2.1e, that is an irrelevant consideration. They are still, within 2.1e, costs of removing cargo and rendering them harmless. But if that were not obvious from the ordinary meaning of the provision, the connecting factor here that is said to make this a claim in respect of damage to the cargo, i.e. the owner's intention to repair the vessel, just shows you the kind of difficulties you get into once you turn away from applying the simple words of the convention, right? Point one, they say this is a claim in respect of damage to the vessel because it was part of their plan, their intention, to clear the vessel so that it could be repaired. The connecting factor between the damage to the vessel and the clearing is their intention to carry out a repair. And you are then disapplying 21E because of the subjective and private thoughts of the owner. They're inviting you to say, oh, look, this is what we had in mind. People may or may not have known that. No suggestion that it was publicly advertised, what they thought privately. And that intention is sufficient to connect the claim to make it a claim in respect of damage to the vessel so as to take it outside Article 2.1. And they're relying on a private intention, which, as one immediately reflects, could change at any time. How do you categorize the case where the connecting factor, their intention, was an intention that they formed after they'd cleared the ship, or which they had at the time they cleared the ship, but they subsequently changed their minds? It's just, it's a very invidious basis on which to found the submission. This is a connecting factor sufficient to displace the literal terms of 2.1e. All right, that's what we say in response to Conti's, this is really a claim in respect of damage to the ship. And that takes me to point 4, which is the insiders-outsiders point. This point was dealt with in detail and forcefully by the judge at paragraphs 79 to 99 of the judgment.
We're on the respondent's notice point now.
This is the respondent's notice point. And I don't intend to repeat what the judge said. I simply make 3 standout points about the insiders-outsiders thesis. First point, there is no basis for it in the text. Not only is there no basis for it in the text, but it's very difficult actually to imagine how you would write it in. The judge took a stab at how you might write it in, saying it would have been easy for the draftsman to write it in, but it involves very significant manipulation of the words used. Secondly, it would give rise to surprising and anomalous effects. It would, in particular, disapply the convention in what one might think of as a number of plain vanilla cases where the convention ought to apply. And you only have to suppose, take a simple example, the owner of a ship who carries a cargo for a charterer. The cargo is damaged or destroyed, and the charterer sues for his own losses flowing from the loss of the cargo. Maybe he's the owner of the cargo, not unusual. Maybe he's just someone who is exposed to a commercial risk in relation to the cargo. Perhaps he's the seller of a cargo, and the cargo is sold at his risk. On Conti's case, in those circumstances, the owner would not be entitled to limit. And yet you might think that that example was the acme case in which the convention would be expected to apply. The judge focused, paragraph 80 of his judgment, on the case that it would, on the case of a container ship, noted, I think I said that it would not be unusual for the charterer to own and therefore claim in the event of a casualty in respect of container shells on board a container ship, but equally, the owner of a container ship might own container shells and want to claim against the charterer. And on the insider-outsider hypothesis, neither of those claims are possible. And that therefore shows the inconsistency of this hypothesis, which admittedly has never been argued before. It's a completely novel hypothesis, but it shows the inconsistency of that hypothesis with Mr. Justice Thomas's analysis of the operation of the convention in the Aegean Sea, which we see at tab 13, pages 235 to 236. So the owners at 235, column 2, heading 2, the claim for bunkers, the owners claimed for the loss of the bunkers that they owned on the ship. And the charterers claimed to limit that, or sought to limit that claim. And the judge held that the charterers were entitled to limit the claim brought by the owners against the charterers. But of course, if Mr. Smith's insiders-outsiders theory were right, that would be plain contrary to the operation of the convention. The owners have suffered their own loss there in respect of the bunkers. It's not a recourse claim, and on his hypothesis, no claims between members of the class of shipowner. Third, as I said this morning, the absurdity which is said to justify the implication of the insiders-outsiders hypothesis does not exist. And although I promised I wouldn't just read out the judgment to you, this point is dealt with very clearly in the judgment at paragraph 85, and it's worth just looking at that. It's page 67 of the core bundle. Sorry, 68. I just invite you to read paragraph 85. And the elegance of that solution lies in the fact that nothing has to be implied into Article 2.1 by way of some kind of implicit exception, because you see once you've read that had Conti established a fund in its particulars of claim, it would have said, as a result of your breach, we had to establish a fund. Our claim is for the cost of doing so, £28 million or whatever it would be, and you owe us that as a consequence of your breach of contract. And if we were to say, but I'm going to limit for that claim, Mr. Smith would say, under which limb of Article 2.1? The answer is, it's not a claim for which Article 2.1 makes any provision. It's a claim which is independent of the limitation regime, which is the basis of the reimbursement sought.
For the purpose of this submission, you are equating the value of the fund and the cost of setting up the fund,
Yeah, the cost
because you're assuming that the whole of the fund will be drawn upon. But that's not necessarily the case, and in this case it may be, but it's not necessarily the case, or it's not necessarily known when the owner or the insider sets up the fund initially.
You're absolutely right. There may be at the end of the day it may be at the end of the day that all claimants against the fund have been paid at par, 100% of the value of their claim, and there is still a residue which can be returned to the...
Yes, I had read, possibly wrongly, I don't know, but I had read the judge's reference to the cost of setting up the fund as meaning perhaps some fees you'd have to pay to the bank, or loss of money in the loss of interest in the meanwhile, rather than actually the amount being paid out. Well, you say he meant the latter.
He definitely, well, that definitely is incautious advocacy, but he when he says the cost of the fund, he means the amount by which the endowing party has what it has lost, and if the matter came to arbitration promptly, the arbitrator's award would be that the guilty party pay the innocent party everything that the innocent party has had to indemnify the innocent party against, everything it has laid out on terms that it, of course, is subrogated to any right to recover the residue. So if the fund has been established in cash, the guilty party will pay £28 million, and it will receive in return the right to any residue that's left over. In the simplest case, the fund is established and paid out, and the innocent party is then able to say, well, I established a fund and it cost £28 million and we've paid all of that out. Can I have £28 million, please? In a more complicated case, the fund has not been fully paid out. The establishing party is indemnified either in cash or in kind by the guilty party, and when the innocent party is thus indemnified, the guilty party, of course, acquires the right to any residue that may be left. But the short point is that what the judge means in this section is whether it's a cost to be established or a cost that has been established, the actual outlay, in other words, the burden of establishing the fund, is covered by, met by, reimbursed by the guilty party. And I'm asked to show you paragraph 87, 5 lines from the bottom. If the innocent party establishes the owner's legal responsibility inter se, then its cargo claim succeeds. it shares in the fund pari passu with all other claimants, and its claim to be reimbursed the value of the fund is a good claim, recoverably independently of the fund, and that is also as it should be. The charter has then not ultimately had to fund the fund, and it makes a net recovery of its rateable share of the tonnage limit, pari passu with other relevant claimants. So there you have, in the expression rather than the cost of the fund, the value of the fund and the funding of the fund. It's payment of the amount of the fund, so that in effect the guilty party becomes the party that has put up the fund. Okay, that's all we say on the insiders outsiders. No basis in the text, give rise to some very surprising practical results, inconsistent with case law to date, and fundamentally not justified by any absurdity in the scheme as it exists. That is all we say in relation to 2.1e, and I now move to 2.1f, and our submissions on MSC's right to limit under 2.1f. We claim to limit under 2.1f in respect of two heads of loss. The first is a liability for around 7 million euros, which was the cost of removing the firefighting water from the vessel. And you can see that the short summary of the facts in relation to that, paragraphs 16 and 17 of the quoted section of the judgment. So that's page 45 of the core bundle. Sorry, 16 to 19 should be. Okay, and then the second element of the claim that we seek to limit under 2.1f is the payments made to the national authorities which permitted the ship to go through the channel to a port of refuge at Wilhelmshaven. And the facts in relation to that, facts that we rely on as founding our right to limit, are at paragraphs 8 to 10 of the same section of the judgment. So that's page 43, just over the page. With respect to both claims, these were costs incurred by Conti in the process of controlling the fire and bringing a stranded vessel to a safe port of refuge. They are therefore
So you say controlling the fire, but the fire was out by this time, presumably. Or was it?
the fire was largely under control, but it continued to
kept on flaring up.
kept on flaring up.
Sorry, this is the cost of removing the firefighting water, not
Yes.
the fire out.
Yes, but hold on.
Okay.
All right. So, as regards the payment to the authorities, which is the first in time, that is an expense of bringing the ship to a safe port of refuge, and it's the ship and, of course, its cargo which are brought. So it's a mitigation or aversion of the loss, the risk of the loss of both ship and cargo. As regards the removing the firefighting water, the step that was taken to control the fire was engaging salvors with a powerful pump and hose which allowed them to spray enough water onto the ship to control the fire. But F doesn't just cover the measure used to minimize or avert the loss. It covers any losses resulting from those measures. Let's just look at 100 of the authorities bundle. Right, so as regards the removing the firefighting water, the bit that we rely on, although I must say we rely on it as just making clear what we would say was anyway the scope of F, but the bit that we particularly rely on is the last 5 words. Right, so the salvors with their powerful hose have been engaged to put out the fire. That is a measure taken to avert or minimize loss for which the person liable, MSC, may limit his liability, because it's to avert or minimize loss of cargo, which is something that we would be entitled to limit our liability for under 21A, and further loss caused by those measures. So the measure, which was engaging the salvors, caused some further loss, which was you had to clean up after the salvors. So that's a judicial moment of.
No, don't.
I mean, if that's not clear, I've repeated in other probably less clear words. But the measure taken, which was engaging the salvors to spray water, was a measure within F, because it was designed to minimize or avert loss of cargo, and it produced further loss in the form of a liability or a necessity to, at considerable cost, remove the firefighting water.
But in relation to the payments to national authorities, you say those come within the first.
Come within. That was a measure bringing the ship. A measure, whether you characterize it as the voyage to the port of refuge or simply the payment to the authorities, which again was designed to minimize or avert a loss of cargo, which is a loss for which MSC would have been entitled to limit its liability. And rather, as I said with E, we say that analysis of the facts of both claims is at least consistent with what we understand to be the only case in which 2.1f has been applied in English case law, which is again Mr. Justice Sheen's decision in the Braden Merchant, where he said that cargo interests claim against owners for the costs that they incurred for salvors was limitable under 2.1f. We should just look at that. That's tab 12 of the authorities bundle.
Sorry, just before we do that, can I just check I got the grammar of F correct? I mean, I think you were saying, and I think this is right, but I just want to say it out loud in case you disagree. The last 5 words to which you refer, further loss caused by such measures, they are governed by, is this correct, measures taken in order to avert or minimize loss. In other words, one has to read in the words taken in order to avert or minimize before further loss. Is that right?
You take a measure,
Yeah.
employing a salvo. You ask, was that measure taken to avert or minimize limitable loss?
Yeah.
Yes, it was. Okay, that's a relevant measure for the purposes of
Yes.
F. And then you say, is the loss that's now being claimed a loss caused by or resulting from taking that measure?
Yes.
So that you take a measure, you employ salvos to minimize loss, and then the salvos, in addition to whatever the straightforward claim in respect of the measure is the cost of the measure, right? You take a measure, you employ salvos, and the claim is for the cost of employing salvos. But the salvos might not just charge their fees for salvaging your property. They might, as they did in this case, actually make a hell of a mess. And that hell of a mess is further loss caused by the measure you've taken. You take a measure to remedy the situation. You engage a crane. The crane then falls, falls on one of your containers and smashes it.
So perhaps I'm just being pedantic, but I mean, it seems to be ultimately as a matter of grammar. That doesn't work because it's got to be a claim of a person other than the person liable in respect of. The claims have to be in respect of measures taken, blah, 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 in order to avert or minimize loss, which the person may limit his liability in accordance with this convention. And what do you read in there? Further claims for, or is it just
claims in respect of A,
yes,
measures,
yeah,
B, further loss caused by such measures.
okay, yes, in respect of A. Okay. Yes, I see. Thank you.
All right, so I said it's at least consistent with the decision in the Braden Merchant, and the relevant part of this decision is page 222, starting at the bottom of the first column. And he's made a decision that the cost of engaging salvos by the charterer's cost of engaging the salvos is limitable under 2.1a. But he says, in case I'm wrong about that, I'll now consider whether the cost of engaging the salvos is limitable under 2.1f. And at the bottom of 222 column 1 and the top of 222 column 2, he says, yes, it's limitable there too. And we just say that paying the national authorities and engaging salvos who create a mess is all akin to engaging salvos. They're analogous.
Mr. Justice Sheen is not dealing with the last few words of F, is he?
No, no.
He's simply saying the cost of engaging salvors is a measure to avert or minimise loss. Yeah.
Okay, there are 4 points against us on 2.1F. The first is the judge's conclusion at paragraph 150 of the judgment that it's not sufficient that a purpose of the relevant mitigation measures would be to avoid limitable loss. It's necessary that that should be the sole purpose of those measures. Then, secondly, there's Conti's argument, very similar to the argument we've already looked at under 2.1e, which they articulate in paragraphs 69 to 70 of their skeleton, which is that properly characterized, these outlays should be regarded as the cost of measures to avert or minimize damage to the ship, and for that reason are not limitable. Okay, there are then two further points which technically are against us, but which I've fully argued already. One is the judge's conclusion about the whole claim being of a single character, and the second is Conti's insider and outsider point, and I'm not going to go back to either of those. So I just have 2 points to address with you. The first is the judge's conclusion that it's not sufficient that the measures be taken in order to avert limitable losses. They must be taken solely in order to avert limited losses. And in relation to that, we say that the judge was wrong to reach that conclusion for 3 reasons. First, again, there's no support for the judge's construction of 2.1F in the text. 2.1F does not qualify the definition of the relevant measures by specifying either that they must have been taken solely for the purpose of limiting or averting limitable loss, or that they must not have been taken for the purpose of averting or mitigating non-limitable loss. In other words, it's just a simple qualifying condition that it be in order to avert minimal limitable loss, and no more precise or exacting requirement than that. Okay. Secondly, we say that the judge's view is not supported by anything in the CMA Jakarta. There is nothing in that decision, while it is right to say that that decision construes 2.1a on the basis that its application is to losses which are caused by damage to the cargo, or which are characterized as damage to the cargo and not damage to the ship. there's nothing in that which implicitly excludes from Article 2.1 claims which satisfy the requirements of any of the limbs of 2.1, but are also in some way related to damage to the ship. And I gave you the examples of Articles 2.1d and E, all of which seem to be explicitly predicated on the assumption that there will be damage to the ship. Thirdly and finally, the solely provision would give rise to arbitrary or capricious results. And we looked at two examples in our skeleton. One was where the secondary or concurrent purpose, we're dealing with a case where there are two purposes served by a measure. And one was where the secondary or concurrent purpose was mitigating a non-limitable loss. And the second was where the secondary or concurrent purpose was just nothing to do with loss aversion at all. And in the case of the first of those, a case very similar to our own, you have a step taken to save the cargo. Can it really be said that if there is no suspicion that there could be any benefit to the ship, that in that case the relevant claim is limitable, but as soon as there was a suspicion of benefit to the ship, as soon as you could say, but in fact the ship was also protected by this, the claim becomes non-limitable. Just seems to set up the question of whether the claim is limitable or not on a basis that is apt to produce unpredictable results.
I can see that. I'm going back to the wording.
Yeah.
We've got to construe and respective measures taken in order to avert or minimise loss.
Yeah.
Is there a distinction between the very subsidiary purpose, the sort of examples you give in your skeleton, and something where the purposes might be equally prominent? Because you've still got to ask yourself, as a matter of ordinary language, was this measure taken in order to avert or minimise loss, which is limitable?
As a matter of the ordinary language of the use of giving that provision its ordinary sense, you don't, in the absence of a qualifier like only or solely, assume that a descriptive condition is an exhaustive description. Okay, if I say this afternoon I visited the British Museum, you don't, in the absence of a qualifier like only or solely, assume that that's the only thing that I did.
Yes,
so
that's not quite the language here.
Okay, if I say I went to,
its question is why you visited the British Museum. Did you go because there was a particular exhibition you were going to a particular exhibition that you wanted to see, or because you wanted to meet a friend in the cafe there, or for both reasons?
Yeah, and if I said I went to the British Museum in order to see the Sumerian exhibition, you don't, in the absence of a qualifier, assume that's the only reason I went. as a matter of ordinary language, in order to, a statement of purpose is not read as being an exhaustive statement of purpose. And likewise, so taking my latest example of, and I think in our skeleton we touched on concurrent purposes, and said, well, you can imagine a range of possibilities. One where one is a dominant purpose and the other is a subsidiary purpose.
I'm asking you about
and
where
for
both are
concurrent,
important.
I mean, different considerations would come into play if saving the ship was the dominant purpose, because then you might say, well, although the subsidiary purpose was present, it can't in any real significant material sense. But if both of them are actual purposes, you don't, in order to meet this condition, have to, as the judge held, demonstrate that that was your only purpose.
But if, going back to the British Museum, if you just said, I went to see the exhibition, when in fact in your mind was, I'm both seeing the exhibition
Having tea with my friend.
and seeing my friend at 4 o'clock in the cafe, just saying, oh, I went to see the exhibition is arguably an incomplete or incorrect description of the reasons that you went there.
If this was a circumstance in which I was being invited to give full disclosure my afternoon, quite so. But if the test is, in order to qualify for this, you have to have been to the British Museum to see the Sumerian exhibition, then going to it for that purpose is sufficient to meet the qualification, even if I have some other purpose in mind.
Now you referred to dominant purpose and you referred to material purpose. Can we just try and pin you down a bit further?
Yeah,
Because you could have a material purpose which is nevertheless not your dominant purpose.
Yeah,
so what's your submission about that?
A purpose, for the purposes of 2.1f, a purpose is, for the purpose of 2.1f, if my purpose is to avert limitable loss, it is sufficient that it is a material or a significant or a real purpose of my action, as opposed to a merely incidental, collateral, minimal, nugatory. In other words,
you go on to say, but need not be dominant.
It certainly need not be dominant. Yeah. So our submission is we qualify if saving the cargo is a material, significant, real, substantial purpose, i.e. some real part of the purpose, as opposed to, well, you kind of could say that at a stretch. So on the facts of this case, we simply say these were equal, co-equal, to concurrent and equal purposes behind the action taken. It was to save both.
But even on your approach, you could argue that that could give rise to capricious results, which was one of your objections. If there was a relatively small amount of cargo or of small value on the ship as compared to the value of the ship, you might still say there was a material purpose of averting damage to the cargo.
Yes.
But it might all. There's a very glaring dividing line there between that and when it becomes incidental.
Of course, characterization involves factual assessment, and at some point the judge, ambitious, take every point kind of counsel, might be one myself, would make some ambitious submission. The judge would say, just sorry, Mr. Cannon, just don't accept.
Yeah, but no one's making a submission that you're somehow dividing up an individual cost between the cost of measures taken to avert damage to the cargo and the cost of measures taken to avert damage to the ship. No one's making that argument.
No,
It's
it
not
can't.
that sort of provision.
It can't. It's ironically salvage itself. It does get apportioned.
Yeah.
All right, but salvage alike provisions such as damage caused by salvors or sums paid to national authorities to permit a salvaged vessel to pass are not apportioned in proportion to. But this comes back to, therefore, the approach to interpretation that I showed you this morning, that this instrument should be interpreted broadly and liberally, so to bring any case that reasonably can be brought within its words, within its wording. Insofar as there's doubt about this, the word should be held to apply.
Is that solely?
That is solely. The second point is that these are claims for Conti's argument at 69 and 70 of its skeleton, that these are actually claims in respect of damage to the ship. And they simply make the genesis and telos points again. And once again we say that cause doesn't determine characterization. It's a question of neither cause nor objective determines characterization. And in considering that submission, we remind you of what the judge rightly said. One of the many occasions he had me skewered about the difference between causation and characterization at paragraph 55 of his judgment. I had made the wrong submission that because certain losses were caused by damage to the cargo, it was sufficient to establish that they were consequential loss arising from damage to the cargo. And the judge said that can't be right, because if cargo is damaged because of damage to the ship, a claim by a cargo owner for compensation for damage to its cargo is not a claim in respect of damage to the ship. And we simply say that demonstrates, that's right, it demonstrates the difference between characterization and causation. Causation may be a nexus factor which plays a part in the characterization of damage as either damage to the ship or damage to the cargo, but it doesn't by itself establish. And for these purposes, therefore, coming back to the context of 2.1f, we simply say that the fact that the relevant measures had to be taken because of, by reason of some damage to the ship, doesn't take them outside the ambit of 2.1f.
Well, doesn't 2.1f have a causation or purpose element built into it? The words in order that we were looking at in connection with the last submission. So something has to be done in order to avert a limitable loss. And therefore it has to be done in order to avert cargo damage. And if it is done to avert ship damage, then it's not a limitable loss. So isn't it a similar point to what we were just
accept
looking at?
all of those propositions except the last. The last, if it's done to avert ship damage, is to treat expenses incurred to avert ship damage as if that were somehow a trump or an overriding principle which excluded what is otherwise limitable loss within F and A, i.e. steps taken to preserve the cargo. And I made the point earlier that merely because there is damage to the ship, which which by itself, the averting of which would not by itself justify limitation under 2.1f, doesn't mean that limitation of the costs of a measure can't be justified under 2.1f insofar as and if it is materially for the purposes of preserving cargo.
Yes, it comes back to your previous submission.
Exactly.
Yes. I mean, I think one of the arguments against you is the judge has made factual findings that this was to avert ship damage or for the purpose of repair. What do you say about that?
Well, I'll have to see which paragraphs are relied upon, but the answer is that he did not. It was he made a finding that the claim as a whole was for the purposes of related to ship damage, and that's the point that we've explored. But as regards the specific claims made under 2.1f, although he says it was always the owner's intention to repair, and we don't challenge that, he doesn't say that these mitigation measures were not taken for the purpose of saving cargo. And there is no finding to that effect. And indeed, but even if ultimately there were a finding that subjectively the owner's management had nothing in mind but the preservation of their own ship and gave no attention or thought to the cargo, it can't be the case that the relevant intention is established by reference to evidence of the subjective intention of the parties. It must be that the objective purpose of the relevant act is the determinative in order to purpose. And here, objectively, if you engage salvors, you engage salvors to save the ship and cargo. And my lady asked me about what the respective shares of the operation were. It's enough perhaps to say that the salvage paid by the owners in respect of the ship was 935,000 euros. So it's a reward based on the value of the property recovered. And the salvage paid to the salvors by cargo interests was 21 million euros. So if you say what objectively was the purpose of this operation, the dominant purpose, it was 21 times saving cargo for every euro spent on saving the ship.
That does beg the question as to whether it is, the concept of objective purpose is not entirely straightforward, but it begs the question a bit as to whether that can be a purely objective test. And whether the sort of criteria you mention are relevant.
Yeah, and the answer is there's no authority on the extent to which the in order to, which, as my Lord Justice Males says, is obviously expressly a purpose-based stipulation.
It's a why question.
It's a why question, exactly. Is objective purpose or subjective purpose, but insofar it's necessary to answer that question, we say obviously it's objective purpose. You couldn't institute a system on the basis of inviting people to come along and say, oh, I never thought of that. No, my eyes were all focused on that. In this context, the only realistic construction of 21F is objective purpose. All right, I come on to 21A, and under 21A, we claim three heads that we've already claimed under 21E and F. So our first claim under 21A is discharge expenses that I spent all morning claiming under 21E. My second claim under 21A is payments to national authorities and firefighting water removal, which obviously we've claimed under 21F. The only new one under 21A is burned waste. And just to show you where the burned waste, the facts on which we rely in relation to the burned waste, they are set out in paragraphs 20 to 30 of the quoted passage, so from core bundle page 45 to 47.
Sorry, could you just give me those paragraph numbers again?
So 20 to 30
Thank you.
at pages 45 to 47.
Yes, thank you.
In relation to the these heads,
sorry, so is the burned waste the 17 million euros, or is that only part of it? It's looking at paragraph 30.5.
it's
24.8. Start of 30 refers to 24.8.
it's 24.8 million.
Oh, I see. That's all. That's all.
all
Yeah. Thank you very much.
costs of and associated with removing the waste. In relation to the discharge expenses, our submission is that this is analogous to the case in the Miss Justice Sheen's decision in the Braden Merchant, in which he held that the costs of charterer's salvage were recoverable as consequential loss caused by damage to cargo under recoverable is limitable as consequential loss caused by damage to cargo under Article 2.1a. And that decision we've looked at briefly for what it said about 2.1f, but the relevant passage concerned with 2.1a is the passage that immediately precedes the passage that we looked at. So that's at tab 12, page 222. And likewise, the similar decision, although obiter, of Mr. Justice Thomas in the Aegean Sea, where again he finds that charterer's liability for salvage is recoverable is limitable under 2.1a, and that's at tab 13, page 329. The points that are taken against us on Article 2.1a are three. First of all, there's the judge's decision at paragraph 69 of his judgment, where he says that the relevant claims are not claims that MSC is entitled to limit under 2.1a, because MSC had no interest in the cargo and wasn't directly harmed by its damage. Sorry. No, I mean MSC, I know. Well, let's see where the submission goes. And
Well, 69 does say Conti was not harmed.
I apologise. I should always take my tips from Mr. Smith when he offers them discreetly. First of all, the judge's decision that Conti's claim is not in respect of damage to the cargo, as Conti had no interest in the cargo, wasn't harmed by damage to the cargo. Secondly, Conti's own similar argument that Article 2.1a is only engaged when the claim is made by the owner of the cargo that's been damaged. And that's an argument that they make in paragraphs 50 and 53 of their skeleton. And then finally, Conti's argument that claims in respect of damage to that the claims in question are all properly characterized as claims for damage to the ship because they were all necessary preludes to repairing the ship, an argument that we've dealt with, addressed before in the context of the two prior limbs that we've examined. So turning to point one, interest, our short submission is that the judge's reliance in the construction of Article 2.1a on the existence or not of an interest in the cargo is a mistake, and that Article 2.1a does not require that the claimant should have an interest in the cargo of any kind. Article 2.1a, given its ordinary meaning, simply applies to claims in respect of physical damage to the relevant kinds of property, including, under the rubric consequential loss, economic losses flowing from the physical damage. And that explanation of the terms of 2.1a as comprising claims in respect of physical damage and claims in respect of economic loss flowing from physical damage is made clear by the Travo, which one finds in volume 3 at page 968. And the commentary that we rely on is paragraph number 400.
Are we dealing here with the terms of the convention as it was finally settled, or is there some other alteration like there was last time?
There's no alteration as far as
the
I'm
final
aware.
text. Okay.
Yeah.
Sorry, this really basic question. I'm probably missing something. In relation to the burned waste, which property are you saying falls within paragraph A?
The cargo that was burnt
But is the burned waste just
damaged,
cargo?
was damaged property.
Okay, I thought it wasn't just cargo. I thought it was bits of the ship.
You're
as well.
right that it comprised cargo, steel from the ship, and water in unknown ratios. But the damage to the cargo had as its consequence the presence of burned waste.
The damage you're referring there to is the explosion and
Fire, exactly. Damage to the cargo had as its consequence the burned waste, and the claim in respect of that burned waste is a claim in respect of having a connection with, regarding, concerning the damaged cargo that was left on board the ship. We recognise it's mixed with other things, but it's nevertheless damaged cargo left on board the ship. So I show you this Travo simply for the proposition that what 2.1a covers is claims in respect of, relating to, damage to property, physical damage to the property, and the economic consequences of that. And there's no suggestion in any of this of it being a convention requirement that there be any interest in the property in order for 21A to apply. Our submission as regards interest is simply that whether a party needs to have an interest in order to make a claim is a matter for the law that applies to the claimant's claim, and who knows under Australian law whether they apply the Spartan steel rule that applies in this jurisdiction with respect to whether a claimant in tort can claim for economic loss where no physical damage has been done. But all of that is the concern of the law applicable to the claimant's claim. The convention doesn't make any such stipulation. It merely asks, is the claim one in relation to or concerning or regarding either physical damage to the cargo or the economic consequences of that damage? And therefore the judge is mistaken when he says that a claimant who makes a claim is only within the ambit of 2.1a if the claimant making the claim has an interest in the relevant cargo. It's just not part of the inquiry. Therefore, corrected by Mr. Smith, it's not part of the inquiry to ask whether Conti had an interest in the cargo. Point 2 is a point.
This is essentially the point of
The APL Sydney.
Lord Diplock, who is quoted by the judge as making the point about the
Yes.
convention not being there to
Exactly.
create claims, but merely to apply limitation to those claims which exist under whatever is the applicable law.
Precisely.
Yeah.
Okay. Point 2. It is a point made in the respondents Conti's skeleton at paragraphs 50 and then more specifically at paragraph 53, where they say the only person whose claim can be limited under Article 2.1a is an owner of the cargo that is damaged. And we simply say, again, that's a more extreme version of the judge's analysis, which should be rejected for the same reasons. There's no basis, particularly in a convention, which applies to limit contractual claims. Contractual claims are not in any way restricted by a qualifying condition of ownership, that the relevant claim be founded upon ownership. And the judge, we submit, rightly rejected that submission in paragraph 59 of the judgment, in which he agrees with Justice Finkelstein's rejection of a similar submission in the APL Sydney, which you find in tab 19 of the authorities bundle, and that the relevant part is paragraphs 27 and 28 of Finkelstein's judgment.
Sorry, which paragraphs are they?
27 and 28.
Sorry, before you that, you gave a reference to something the judge had said. Which
So
paragraph
the
is
judge agrees with Justice Finkelstein, and he did that at paragraph 59 of the judgment.
that? Thank you.
Page 61 of the bundle. And his agreement with Mr. Justice Finkelstein is with a judgment you find in paragraph 9, in tab 19 of the authorities bundle. The relevant paragraphs are 27 and 28. Final limb of this, it is said that the final point taken against us, it is said that each of the cases, each of the claims which we say are limitable under Article 2.1a should more properly be characterized as claims for damage to the ship rather than claims for damage to cargo. And here we face in its rawest form the dichotomy in the CMA Jakarta, because here you are asking yourself the question, are these claims for damage to the cargo legitimately within 2.1a, or should they be characterized as damage to the ship? And those are mutually exclusive alternatives insofar as you are applying 2.1a. Got to be one side of the line or the other. And we simply say that in that characterization exercise, the proper considerations are not genesis or telos. Proper considerations is the closeness of the connection between the nature of the claim and either damage to cargo or damage to the ship. And in each of the 4 cases which we say are limitable under Article 2.1a, the closest connection between the claims that are made for discharging expenses, etc., is between damage to the ship, between damage to the cargo and those claims, rather than damage to the ship.
Because?
In the case of discharging expenses, because it's all about the cargo, the cargo is in, as Mr. Justice Sheen had it in the Braden Merchant, in a position where it requires to be redeemed from a position of devaluation on board a lame ship, contaminated, and that exercise of discharging and cleaning was primarily about saving the cargo. It was only ulteriorly about whatever plans the owners may have had ultimately for repairing the ship. In the case of the mitigation expenses, i.e. payments to national authorities and removing the cargo, although there were 2 interests involved, the relationship to damage to the cargo and damage to the ship, it's not obvious that one or the other was dominant. In fact, by reference to the values of those respective interests, the closeness of connection between the damage to the cargo and the mitigation expenditure justifies regarding these as those claims as claims for expenses in relation to damage to the cargo rather than damage to the ship.
You're going back to the figures you gave earlier, then,
Yeah.
are you? Salvers, the figures, payments to salvers.
And then finally, as regards the
And just those figures are not the value of the cargo, but simply the ratio of the values of the ship and the cargo.
Exactly. It's a salvage award based on the respective values of ship and cargo.
Yes.
And then finally, as regards burnt cargo, the closest connection between the costs of dealing with burnt cargo is not, again, whatever ulterior purpose the owners may have had, but its connection with the need to deal with the cargo that was at hand in its burnt form.
Okay, does that make an assumption that the burned waste was primarily cargo, or does it? That seems to be what you're saying, though you said earlier it's the unknown proportion.
It's the product of burnt cargo, although I accept that the ratios are unknown.
I think we are told that the majority of the waste consisted of cargo or cargo containers, which I suppose is on the cargo side of the line.
Yeah. Right. That.
What if it's not possible to say that one or other has a closer connection?
The instrument should be read broadly and liberally and should be applied to facts before the court wherever possible. Cases of doubt should be resolved in favour of upholding the right to limit.
All right.
No, that's all we say.
Yes. Thank you very much, Mr. Kenny. Yes, Mr. Smith.
My lords, my lady, before I dive into my submission, could I, perhaps through the court, ask my learned friend to clarify one point? Because on 3 occasions, when dealing with Article 21A, he said these are claims that we are limitable because they are claims in respect of damage to the cargo. Now, that was, I don't like taking pleading points at any stage, but that was not his pleaded case before the judge, nor is it the case that he advances in his skeleton argument. I had always understood his case under Article 21A to be that the respective claims are for consequential losses in respect of damage to the cargo. Now, I'm not going to come to Article 21A today, but I do need to know whether the goalposts have fundamentally changed from, and if one looks at his skeleton argument at page 286 in the bundle, paragraph 64, Article 21A provides that consequential losses resulting from loss of or damage to the property on board are limitable. And MSC's case at paragraph 65 is that the expenses, the claims that my learned friend has addressed this afternoon fall within that category. But he has said on 3 occasions this afternoon that he's labelling them directly as claims in respect of loss of the cargo. So I don't know if you can clarify now or perhaps overnight. So at least.
Right, well, do you want to comment on that now, or do you want to speak to Mr. Smith and see if you can sort things out afterwards?
Let me just say, because
yes,
you may hear the answer as well. My submission earlier was that the inclusion of the words consequential loss was merely to put beyond doubt that economic loss resulting from physical damage was also limitable. And for that proposition, I showed you the Travo. So insofar as all of the relevant losses that we say are limitable under 21A are economic losses flowing from the physical damage to the cargo. They're all consequential losses, and I don't change, I adhere to the position I've always taken on this. I may have in shorthand terms said this is closely connected with physical damage, but that's because consequential loss and the claims in respect of physical damage are just the physical and economic sides of the same coin.
That helps, my lord, and I'm grateful to my learned friend for clarifying. My lords, my lady, I'm going to start with a very brief overview of our submissions, including a roadmap of where I'm going to go in our submissions. And that overview is to make the perhaps obvious but nonetheless important point that the right to limit to an amount calculated by reference to the tonnage of the vessel is a privilege that's enjoyed by owners and obviously others, otherwise we wouldn't be here debating how far the others went. And it's a necessary consequence of that right that an innocent party who's suffered loss and damage as a result of a tort or a breach of contract on the part of the limiting party will recover only a proportion, and in many cases only a very small proportion, of the loss that they have suffered or been awarded. Now, we don't say that's a bad thing per se. I'm not taking a sort of jury point that it's terribly unfair to my clients that we'll only get 1/10 of our claim. It's a matter of policy, as my learned friend has said, to encourage investment in shipping, that those involved in the operation of the ship should be entitled to limit their liability, both to encourage investment and I think it's fair to say, although this wasn't in any of the authorities my learned friend took you to facilitate the purchase of affordable insurance in circumstances where the cost of that insurance is ultimately going to be borne by the parties who are going to be claiming on the fund. In other words, passed to the customer at the end of the day. But, and we do say this is important, the fact that tonnage limitation operates in this way means that the provisions of the Convention need to be carefully construed and applied to ensure that only those claims which are intended to be limitable are limited. And so we would respectfully suggest that the words of the Convention should be given their ordinary meaning in the context and in the light of the object and purpose of the Limitation Convention. And my learned friend referred you, I think, earlier to the Vienna Convention. If I could just ask you to have that in the authorities bundle, volume 1, divider 6, page 67, the convention starts. And Article 31 at page 78 is the general rule of interpretation. A treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. So when seeking to discern the ordinary meaning of the words, you need to put them in their context, but also their object and purpose. Paragraph 2, the context for the purposes of the interpretation of a treaty shall comprise, in addition to its text, including its preamble and annexes, any agreement relating to the treaty and any instrument made. And neither of those applies in our case. There are no such side agreements or instruments between the contracting parties. And also paragraph 3, that should be taken into account together with the context, any subsequent agreement between the parties. But again, we're not concerned with that. And then Article 32 is headed supplementary means of interpretation. Recourse may be had to supplementary means of interpretation, including the preparatory work, so that the travo that we've seen, and the circumstances of its conclusion, and we will say that includes the conventions that went before it and the established meaning that various phrases had under those conventions, in order to confirm the meaning resulting from the application of Article 31, or to determine the meaning when the interpretation according to Article 31 leaves the meaning ambiguous or obscure or leads to a result which is manifestly absurd and unreasonable. And the court will be aware that we rely on those provisions in relation to our insider-outsider argument, which I will come back to later. And we would
it sounds as if your initial point that you interpret the convention carefully to ensure that only those claims intended to be limited are limitable, as the sounded like the opposite of broad and liberal. Is that what you're saying?
My next submission was there is no basis for suggesting that the English words should be construed, first of all, literally. My learned friend says in a number of places in his skeleton, paragraph 36 and 37 in particular, that the court should construe the words literally. Still less, I was about to submit, for saying that the words should be construed broadly and liberally, as my learned friends say in their skeleton argument, relying in particular on a United States decision from 1941, which we would respectfully suggest is not a good basis for reinventing what is said in the Vienna Convention. That decision predates the convention. It was made by reference to statutory provisions in force in the US, which were very different from the convention, and we would suggest does not reflect English law. And when one is considering the provisions that the court has to consider in relation to this appeal, and particularly when we come to look at the insider-outsider argument, the court is considering the reasons why the right to limit was extended to include charterers, and whether the limitation claimants, so MSC in this case, can bring themselves within those provisions. So that is why a broad and liberal approach is not in our submission appropriate. And one can come back to that, for example, well, I will come back to that, in relation to the question of mitigation expenses and the judge's adoption of the word solely in relation to that. Because the convention specifically provides, as we've seen and I'll come back to tomorrow, in Article 2.1f, a right to limit for mitigation expenses that are intended to mitigate a limitable loss. So if you are engaging in a measure that is intended to mitigate a non-limitable loss, then because you are assimilating the loss and the mitigation measures, as the judge said, then you should not be allowing limitation in relation to the mitigation measure. So that's why we say it's important. Yes, one has to look at the fact that the convention is there to permit limitation for good public policy reasons. But one also has to look at the fact that it defines the circumstances in which limitation is permitted and those who are entitled to the benefit of it. So we would suggest that any wide or generous or liberal interpretation of the convention overlooks the fact that encouragement is given to shipping and to the investment in shipping by a carefully defined series of provisions. Pause to say there, perhaps not quite as carefully defined as they could be, otherwise again we wouldn't be here, but it would be wrong in our submission to seek to give what would in fact be greater encouragement to shipping than the convention intends by allowing a broader right to limit. So the limiting party is entitled to limit when the claimant is making a claim of the kind set out in Article 1, but not otherwise. And the second point my learned friend made in relation to the purpose of the convention, this is paragraph 24.2 of his skeleton, he made the same point orally today, was that the object is the intention include ensuring an equitable distribution of compensation between claimants. And he likened the position to a liquidation. And that, with respect, was not a good analogy, because in a liquidation, with possibly certain very limited exceptions, all the creditors have got to prove their claim in the liquidation and rank accordingly depending on whether they are secured or not. In a limitation situation, only those claimants who make claims that are covered by Article 2.1 are obliged to claim against the fund. And so the policy driver of ensuring an equitable distribution can only mean between those who are obliged to claim on the fund. So in relying on that as one of the policy reasons behind the convention, my learned friend has, with respect, put the cart before the horse, because we need to determine whether these are limitable claims before we can consider the public policy requirement to ensure equitable distribution. And see, and I'll come back to the APL Sydney later, but there's a passage at paragraph 8 of that judgment dealing with precisely that point. And so, against that background, my submissions are going to follow, I hope, the following roadmap. Firstly, I'm going to look at some key facts. And the reason for doing that is, as the court will be aware, the judge set out in his judgment certain facts that were common ground. And my learned friend has taken you to various extracts from that document. It was an agreed document produced as part of the case management process in the Admiralty Court. But the judge also made certain other key findings at paragraph 25 of his judgment and in the appendix. And none of these findings are challenged on appeal. I'm going to go through just some of them, which we suggest are of considerable importance in relation to the exercise of characterization that the court is being asked to carry out. Not least because what we do have here is a case where there is clear and binding Court of Appeal authority on the question of limitation by charterers, approved, albeit obiter, in the Supreme Court decision in the Ocean Victory, and essentially findings of fact by the judge as to the proper characterization of these claims for the purposes of that test. And we say, therefore, conclusions as to limitability that are unassailable. So I'm going to deal with the key findings of fact, and then I'm going to deal with the issues that arise in the following order. And this tracks the order we took in our skeleton argument. I'm going to deal first with the insider-outsider argument. And the reason I'm going to deal with that first is twofold. Firstly, if we're right, it disposes of the whole appeal. Secondly, and in some sense more importantly, is that even if we are not right at the headline level, that a charterer cannot limit in respect of claims made against it by a fellow member of the, as I called it at first instance, the genus, by another insider. Nonetheless, the arguments and reasons that we rely on in support of that submission apply equally to the individual characterization process that my learned friend invites you to undertake. So whether we are looking at Article 2.1a or 2.1e or 2.1f, and either limb of Article 2.1f, many of the points I rely on in relation to the headline insider-outsider point are equally relevant. So, for example, what is the consequence of permitting a charterer to limit its liability in these circumstances? And that's where we come to the absurdity argument. So if I can't persuade you that there's a headline prohibition, as it were, on charterers limiting in respect of claims by owners, nonetheless we do submit that looking at each of the individual claims and the subparagraphs of Article 2.1, those points are pertinent to the court's consideration. Next, I'm going to deal with issue 3, what I call the headline characterization point. This is the judge's conclusion that for the purposes of limitation, these claims are all claims in respect of damage to the ship and consequential losses. And again, the reason for taking that second is that MSC accept in their notice of appeal, and certainly in their permission to appeal skeleton, although they didn't say as much in their actual appeal skeleton, that if we are right on this point, the appeal fails and none of the other points assist them. Then I'm going to deal with what my learned friends in their skeleton call issue 4, that is Article 2.1a. And I'm going to deal with that first because it's been described as the hard core in the definition of limitable claims. It's, as it were, the main catch-all provision, and the other items are subsidiary to it. And that's a quote, and I'll come back to it, from paragraph 20 of the APL Sydney, quoting from the Travaux Préparatoires, which we can look at later. And then I'm going to deal with, finally, Article 2.1e, which is issue 1, and 2.1f, which is issue 2. So, in terms of key facts, in the underlying arbitration, as my learned friend has said, our claim was for damages for breach of the Charter Party or an indemnity pursuant to Article 4, Rule 6 of the Hague or Hague-Visby rules. The basis of that claim, as the court is aware, is that MSC had shipped a dangerous cargo, the 80% DVB, that auto-polymerized and vented from the tanks, leading to an explosion and fire. We claimed both direct and consequential loss and damage, made up of thousands of heads of claim, if I can use that phrase neutrally before we come on to questions of characterisation. And the court can see those in the core bundle at tab 17. The spreadsheet is there as it was before the arbitrators. We don't need to look it up.
You say the court can see them. I'm not quite sure about that.
With a magnifying glass, possibly.
The court can see the many thousands of claims, even if the court, well, certainly I can't read them.
No. What about the colour coding? I mean, it all looks very pretty, but is there any relevance, or is it an aid to understanding, or?
As a survivor, can I say that it referred to whether the claims were admitted, challenged, or were subject to further information?
I see. It's nothing to do with categorization of the claims, in other words.
It was before limitation was even dreamt of.
Thank you. So it's completely irrelevant.
Moving on, however, the claims were, for presentational purposes, if I can put it that way, grouped together into a number of headings, which you do see at divider 16 in a document headed Claim Summary by heading in Annex 1. This was our document in the arbitration, and the claim headings there are rather different to those that subsequently appeared in the limitation action. And that's an important point because we've divided the claims up between salvage, disputed and litigated claims, which is neighbouring countries, costs in Germany, costs in Romania, costs in Denmark, general costs, and then there's charter hire and the like. So that is the extent to which the claims were attributed to headings or categories in the arbitration. In its original limitation pleading, which is titled MSC's Further Particulars in relation to Article 2, MSC, which the court has at divider 12, divided these costs up and allocated new headings to them. And so if we could start at page 122 in the core bundle, how this worked was, first of all, salvage is the heading at A1 at the top of page 122. And at paragraph 13, the plea is that owners have made a claim against MSC in respect to the costs of engaging Smith, which were approximately €935,000 C6. And the numbers in bold are to line numbers in the document I showed you a moment ago at divider 16. So we could cross-reference them if necessary, but I don't think we need to. And then for each of the claims, or groups of claims, in respect of which MSC argued that it was entitled to limit, they identified the lines from our annex. So again, we see in relation to the passage to Wilhelmshaven, owners have made claims against MSC in respect to the sums paid, totaling approximately 1.9 million. But in this document, the categories of claim in respect of which MSC said it was entitled to limit were headed A1, salvage, that's on page 152. A2, the passage to Wilhelmshaven. A3, costs of discharging, cleaning, storing, transshipping and releasing the cargo. Just pause there to emphasise the words transshipping in relation to a question my Lord Justice Mayles asked this morning about whether transshipping and on-carriage might ever come within the right to limit. These costs included transshipping costs. And then going on to page 125, A4, costs of removing the firefighting water. A5, costs of removing the waste from the ship. A6, the repair of the vessel, somewhat ambitiously at first instance MSC sought to limit their liability in respect of the actual repair costs. And then A7, miscellaneous costs and expenses, including litigation costs. So those categorisations were, however, MSC's categorisations. And we worked with them in the sense of the pleadings in the underlying action. But that didn't alter, and they don't define how those claims should be categorised for limitation purposes. And it has suggested at paragraph 16 of my learned friend's skeleton that those 7 headings reflect how we advanced the case in the arbitration, but that's not quite correct. They pick up on certain items and then put them under new headings. And they alleged that all of the claims were limitable under Article 2.1a. And they then alleged that some of the claims were limitable under Article 2.1e and 2.1f as well. And we'll look at the ones that survive, because not all of the claims to limitation made at first instance are being renewed on appeal. And in relation to the costs that we claimed that made up those various line items in the spreadsheet, the key findings of fact made by the judge, and if we could have the judgment please open at C tab 5, although I'm afraid it's in the nature of the exercise that we may have to flit around in C tab 5, because some of the judge's findings are made where he referred to the common ground. Some of the judge's findings were made in an appendix, and some of the judge's findings were made in response to a document that I submitted setting out further key findings of fact we asked him to make. But I'm going to try and group those together into logical groups, but it may mean that the page references skip about a bit. Firstly, at paragraph A8, so that's appendix 8 on page 89, the fire on the ship caused such extensive damage to the ship that there were serious concerns regarding the integrity of what remained of her. And so on any basis, this was a serious casualty for the ship herself. And this included shell plating, bulkheads, cargo hatches, fittings and surrounding in holes 4, 5 and 6. And that's paragraph 5, the main judgment at page 43. In response to the fire, we engaged Salvors, Stolt Tank BV, and this afternoon, I think it was my Lord Justice Mayles asked, I apologise if it wasn't, but I think it was, asked whether there was any finding as to the motive, as it were, in engaging the Salvors. And my learned friend said he'd wait to see what I had to say on that. And that's at paragraph 149 of the judgment, page 81. The judge has recorded at page 148 that superficially Mr. Kenny has a point that the salvage was engaged in order to mitigate the cargo loss, in order to salve the cargo. But the judge then goes on to say, however, at least equally, Conti engaged the Salvors and they extinguished the fire in order to avoid the loss of and minimise damage to the ship. So we'll come on later when we consider 2(1)(f) the consequence of that. But there is the finding of fact. And not challenged on this appeal. The next key finding is that under clause 1 of the time charter article, owners were contractually obliged to repair the damage and return the vessel to service. That finding appears at paragraph 111 of the judgment on page 73. So my learned friend made much today about my client's motive, whether it was private or confidential, whether anybody knew or why they might want to return the ship to service, or whether they would carry out repairs. But there is a finding of fact that my clients were contractually obliged to do so. There is also a finding of fact, which is at paragraph A10, so paragraph 10 of the appendix, on page 90, and paragraph 25(1) of the judgment on page 50. So, page 90, A10, and to the like effect at page 50, that the time charter between my clients and MSC was extremely profitable, and it was our intention from the outset to repair the vessel if possible. And while we have A10 open, I'll come on to it, but while we have it open, just to save turning it up again, A10, the judge also found that even before the vessel arrived at Wilhelmshaven, owners had asked GL, that's Germanische Lloyd, who were the vessel's class and were providing assistance in assessing the structural stability of the vessel, to prepare a possible condition in which the ship might proceed to the repair yard. In the arbitration, it was MSC's positive case that Conti was under a legal obligation to repair the vessel under clause 1. So, as a result of the casualty, the ship was unable to complete her voyage. That's paragraph 25, Roman 1 at page 50. And she had to proceed to a port of refuge. And there were very few disputes between my learned friend and I about findings of fact at first instance. But one of them was this. MSC said that the reason the ship couldn't proceed to a port, couldn't proceed with the voyage, was due to the damage to the cargo and damage to the structure of the ship. We said that the damage to the cargo was not, as such, the reason why the ship couldn't proceed. It was the damage to the ship. And I'm just giving myself a wrong reference, which I apologise. Page 43, the judge sets out his conclusions on this. And he records at paragraph 8.1 the dispute I've just mentioned. And then at paragraph 83, 8.3, he says, on that it seems very artificial, given the nature of the cargo explosion and the fire, to posit the cargo being damaged as severely as it was without the ship being as damaged as it was. But, if it matters, my conclusion and finding on the evidence is that on one hand, it was only the extent of the damage to the ship that meant that she could not complete her voyage. On the other hand, even if the ship had been undamaged or damaged to a much lesser extent, diversion to Wilhelmshaven to deal with the wrecked or badly damaged cargo and the byproducts of the firefighting the water, rather than direct progress to Antwerp, Antwerp was the intended destination, would surely have been required. So it was, we say, the damage to the ship that meant that it was necessary to proceed to a port of refuge.
Right. How much more of this little exercise is there?
On the factual parts, I'm just over halfway through.
Right.
I'm happy to take tomorrow.
All right, well, let's resume that tomorrow, shall we? I mean, you're in good shape to finish the case tomorrow, I'm sure.
Yes.
Yes is the right answer. 10:30.
seconds to go.
No, it's
And then